As Tess said, my name is Raya McKenzie. I'm an associate lawyer at JB Lawyers in Victoria. I am going to start the presentation here and I will try to share my screen with you so you can see what we're looking at. Share screen. And
Yeah, that worked. That's good.
okay, does it have all my notes on it or is it just the main presentation?
Uh, it looks like it has some notes under the slide.
Okay, I'll try to get it going a little better. Is that better?
We're still seeing your view of it with the notes and the slide that's upcoming.
Oh, that stinks. Let me see if I can switch the screen here. Uh, um,
You might have to stop share and then
yeah,
reshare.
sorry, I'm not stop share and share.
Are you using presenter view? Do you have two monitors
I
defined?
have two monitors. I'm just figuring out how to do it here. Can you see it now?
Yeah, that's it.
Okay, that's it. Okay, so today we're going to talk about charitable giving in estate planning. So if you've been to my other presentations for TB Vets, I've done two. I've done one on just estate planning in general, and I've done another one on estate planning for blended families. So some of the information in here will be review. I am also making this presentation with a general sense that people know from the original sort of fundamentals of estate planning, what we're talking about. So wills, powers of attorney, rep agreements, we have a general sense of what an estate plan is. This one is mostly going to talk about the will. So even if you haven't been to that other presentation, you probably have a sense of what a will is and how that occurs. So I'll go about it that way. But if we get confused, let me know. Okay. And then are you on my second slide? Or are we still on my first slide here? Let me,
Still on the first one.
okay, there we go. Okay, so some disclaimers. Each person's situation is different and unique, so the information I'm giving you here is not for specific legal advice, it's just for your general information. Another very important point, please note, I am not a tax expert. So though I practice in areas that involve tax law, tax is mostly actually driven by your accountant rather than a lawyer. Tax lawyers, like specialized tax lawyers, can get involved when you have really thorny tax issues, usually when the government's coming after you for something. But for the most part, it's actually your accountant that drives those tax considerations. So I am going to touch on some taxy stuff here, but this is not meant to be a tax advice program. It's mostly about how you would give to charities in your will or outside of your will. There are some tax benefits associated with that, but that's not mostly what we're going to talk about here. A little bit, but not entirely. Okay, so here's some key terms from my prior presentations that we'll go through as a refresher or as a first time for some of you. So the estate, that is the legal vehicle that comes into being after a person's death and includes mostly all of the assets you had at the time of that you died. Sometimes not, and we'll talk about some assets that are excluded from an estate. Main ones being tax-free savings accounts, registered retirement savings plans, or registered retirement income funds, so RRSPs and RIFs, that name beneficiaries. Those are excluded from your estate, but we can talk about that as we go through. Trustee and executor, same role. It's the person responsible for administering an estate. It's usually a close family member or a friend of the deceased, but it can be a neutral third party, such as a trust company or a lawyer. So that's the person who actually deals with your taxes, deals with making your gifts in your will, deals with cleaning out your house or apartment. They're the one that is in charge when you pass away. Residue. Residue makes you think of a gross substance left behind. That's not really what it is in the context of estate planning. It's actually the majority of your estate. So that's the bulk of your estate that is left over, or residue, once you've paid your taxes and any more specific amounts that you've left to other charities or friends or things like that. So residue means the bulk of the estate most often. Probate is a legal process. It's a court desk order that proves the validity of your will and allows your executor to complete the administration of your estate. There are fees that are charged on anything passing through your estate for probate. It's about 1.4% of your estate. There are ways to avoid probate, which I've discussed in prior presentations, and people are really stressed out about probate often, but it's really not the worst thing in the world. It's better to go through probate than to cause your estate unnecessary complications. So those are some key terms we're going to talk about as we go through. So now we've kind of set the groundwork. Here's my outline of what we're going to talk about today. So we're going to talk about reasons to include charities in your estate planning, the types of charitable gifts that you can make, and then some important considerations. So the reasons to include charities, I've divided this into two general ideas as to why you might. Legacy reasons, so reasons dealing with you as a person, your values, interests during your lifetime, what you want your legacy and inheritance to be. Often in that one, we think about relatives don't need the money, or giving to your relatives is not really reflective of your values and interests that you had while you were alive. And then another category of reasons is the legal reasons. So legal reasons why you might give to charity. Locking trusts, we're going to talk about that in a second, but you can use charitable beneficiaries to help protect assets from family members who might be too young or otherwise not able to manage assets. And then there's some tax benefits as well. So the bigger one actually, I think, is legacy. When all said and done, the main reason to leave to charity in your will is because you want to, and it reflects your values as a person. So these are some reflections that you might consider when deciding to leave to charity or to what charities. So what shaped you as a person? How have you dedicated your life and resources? How do you want to share resources after you die? Who would inherit your resources otherwise? And does that align with your sense of self and your hopes for your legacy? So yes, there are some tax benefits and or legal reasons why you might donate to charity, but those pale in comparison to the main reason of it's something that you want to do and it makes sense for you. Okay, so one of the reasons that we also consider leaving to charity is when we think about who might inherit the estate otherwise. So this slide's called The Realities of Intestacy. Intestacy just means when you die without a will. And this is going through what happens if you do die without a will. Most people get this sense that if they don't have a will, somehow their money could go to the government or could go somewhere they don't want it to go. And that's not really true. It's not very common. So we'll discuss what would happen. So if you have a spouse, but no children, everything goes to your spouse. Pretty straightforward. If you have a spouse and children, your estate would go to your children and your spouse. And the proportions of how much goes to your children and how much goes to your spouse depends on whether your spouse and you have children in common or if you don't. So I won't get into the nitty-gritties on that, but if you're living, if you have a living spouse and children, it goes to them. If you have no living spouse and you have no children, it would first go up to your parents if they're living. If not, then to your siblings equally. If not, then to your nieces and nephews per each share for your siblings. So if you have 3 siblings and one has 1 child and one has 2 children and one has no children, it'll be divided amongst per each sibling. So the one that had 1 child, that 1 child would get more than the sibling that had 2 children, if that makes sense. If you don't have any nieces and nephews, we're going back up to your first cousins. And then it can get even more distant than that. But you will not be able to leave your assets without a will. So if you don't have a will and you have no family that's related to you to the fifth degree, and I'll explain what the fifth degree looks like in a second here, but past the fifth degree, that's when we get into the territory of the government can get your estate. If you don't have a will. If you do have a will, you can leave it to charity, to relatives, you'll be okay. And as you'll see, the fifth degree is actually fairly hard to reach. Most people have relatives closer than the fifth degree. So this is the fifth degree and other puzzles. This is an example of a family tree where you can see how far distantly you have to be related to get to the fifth degree. So I'm going to have you look at Pamela. Pamela is down here in red, shows her as 60 years old. She's sort of our subject test that we're going to look at. You can see her mother, Lisa, her grandmother, Elizabeth, and her great-grandfather, Harold. Now, how we find out what degree Pamela is related to people, you count up the generations and then you count down. So between Pamela and Lisa, that's 1. Between Lisa and Elizabeth is 2, Elizabeth and Harold is 3. Then we count down. So from Harold to Rachel is 4, and then from Rachel and Robert, 5. So Pamela is related in the fifth degree to Robert and Teresa, cousins of her. They're not her first cousins, but relatives of hers over here. So if she died without a will, if Pamela died without a will, her estate would go to Robert and Teresa because they're still related to her in the fifth degree. But she would not be able to inherit, to pass her estate without a will to the 6. So you see number 6 by Leslie, Gail, James, that generation. That wouldn't work, and neither would it for number 7. So Pamela is a prime candidate, actually, to consider charitable donations because she doesn't have a lot of people in her family that are closely related to her. She might be related or closely associated with her fifth degree relatives over here. She might be really close to Robert and Teresa and their kids, but she might not. Not sure. I've also highlighted 2 other relatives on this fake family tree. Gail, who you'll see in blue here, and Diana, who you'll see in green. We'll talk about Diana on the next slide, but the reason I've highlighted Gail is she's another candidate for giving to charity because, as you see, she doesn't have any children and she doesn't have a spouse. Those people are the most free in terms of where they can leave their estate. So there is a presumption in the law that you must provide for your spouse and children, and that's quite a strong presumption. We'll talk more about that as we go through on, that can get quite complicated. But someone like Gail is totally unencumbered. She can leave her estate wherever she wants. She could leave it to her nieces, Natasha and Megan down here. She could leave it to cousins. She could leave it to charity. She can do whatever she wants. And it may be the case that she doesn't particularly want to leave it to her sister Leslie or to her nieces. She may have interests in charity or friends or other people or interests that reflect her legacy better. So she is well situated to be that kind of a donor. Locking trusts. So we're talking more about some legal reasons. So we talked a bit about the legacy reasons, and people might not be, your closest relatives may not be the people you really want to inherit. Another reason you may use a charitable donation is to lock a trust from relatives that you want to inherit, but they're not equipped to manage that inheritance. So here's Diana from our prior family tree. You'll see she's 54 years old and she has a daughter, Heather, who's 18. So my sample facts here, Diana has 1 child, Heather. She's going to have her sister Gail be the executor and trustee. And Diana wants Heather to inherit all of the estate at 25, but not earlier. So Heather's still young. Diana doesn't want Heather inheriting at 18, 19, and potentially not spending that wisely. Okay, so here's the problem. Even if Diana says in her will that the inheritance is not to be given to Heather until Heather reaches the age of 25 years, there is a law, a very old law, called the Rule in Saunders and Vautier. which basically says when an inheritance is delayed only by reason of age, if all the beneficiaries are over the age of majority and they consent to distribute the estate early, then the executor or trustee must distribute the estate early. So what this means in layman's terms is if Diana, in our example, dies while Heather is under 25 years, if Heather reaches the age of majority, 19 in British Columbia, she will be able to claim the entire estate from her aunt, Gail, who is the trustee, and she will require Gail to pay it to her, and there's nothing Gail can do about it. The only way we can stop this from happening is if we add another beneficiary or possible beneficiary who won't consent to that early distribution. So who might that be? Well, charity is a good option. So you'll see some possible solutions to how to lock a trust like this to make sure that Heather is not going to be getting that money until the age that her mother has specified. So you need to name alternate beneficiaries who are not yet of age or not been born as an option. So for example, you can say, if Heather dies before attaining the age of 25, then I direct my trustee to distribute the remaining residue of my estate among the children of Heather as are then living on their attaining the age of 25 years. What this does is we're protecting the estate for the next generation, Heather's kids. And since Heather's kids are not going to be potentially born or of age while Heather is under 25 years, they cannot consent to the early distribution because they either don't exist or don't have the legal authority because they're still children. So that keeps our trust protected until Heather is 25. Another option is to name an alternate beneficiary who would just never consent to an early distribution, a charity. So something like if Heather dies before attaining the age of 25 years, then I direct my trustee to distribute the remaining residue of my estate to TB Vets Charitable Foundation. In this case, TB Vets, in this example, would have to consent to the trust being ended early and Heather receiving all of that money before the age of 25 years. And typically charities will not consent. They do not want to consent to that because there's always the possibility if Heather dies young, under age 25, that the charity could inherit the bulk of the estate. So they typically will not consent. There are some charities that will consent to an early distribution because they do not want to rock the boat. They don't want to cause trouble in the family. They would rather just say, fine, Heather, you can have it, even though you're only 23, whatever the case might be. So you do want to check it out if you're thinking of locking a trust by using an alternate beneficiary as a charity. Good idea to check and see if they are the type that would agree to an early termination and on what terms. So some people might be comfortable enough saying, sure, like you can agree to terminate the trust early if you think that my grandchild is mature enough. You don't see any reason that they would spend it, but if it's not looking good, don't consent. Okay, now we're going to move on to another benefit of giving to charity, which is, of course, tax benefits. There's generally two kinds of tax benefits: donation receipts and then avoiding capital gains. So as most of you are probably familiar with from donating to charity during your lifetime, a donation receipt is issued to offset your taxable income in each tax year. So you can use these in a person's lifetime, and then after death, the credit can be claimed for the year of death or in the year that the gift is made. So let's say your estate gives a gift and they actually don't distribute that gift until a year after you've died. They can use that tax credit for your last tax year when you were alive or in the same tax year they actually made the distribution. And then the other one is avoiding capital gains. So most people have the sense that giving stock portfolios to a charity is a good choice. It can be. So you can actually give capital property to a charity like a stock portfolio, provided they're publicly traded stocks. And this can reduce, so some of you, just to back up, so capital gains are generated when you have an asset that appreciates in value over time, and then you sell that asset that generates a capital gain on the increase in value of that asset. So if you give your capital property to a charity, normally a gift would trigger a capital gain. The government would essentially pretend that you sold your stock portfolio and made money off of it, and they want to tax that. The way that it currently is, if you give that portfolio to a charity, you're not selling it or gifting it to someone else, the government will give you a capital gain inclusion rate of 0%. So you will not be paying capital gains on that gift. It will just go over to the charity. But note that this might change soon. So the government is looking at reducing the benefits for giving those kinds of gifts to charity, and also in giving gifts in donation receipts as well. So this might be the time to give. The other way, so after death, capital gains are deemed to happen. So whether or not you actually sell your stock portfolio or you actually sell your rental property, the government pretends as if you sold it and taxes you on that gain. And so in your last year of life, your tax bill is going to be much larger than it was in any other year that you have been alive, because you've got that big gain waiting for you. For a lot of people, it's significant. If you are donating to charity in your will, that capital gain is going to happen, but your charitable donation credits that you receive from making your donations can help reduce that gain or pretty well neutralize it. We're going to talk now about some types of charitable gifts that you can make and why you might make one or another. So you'll see my categories I've laid out here. So there's gifts in a will, or we call them testamentary gifts. Gifts that occur on your death but don't actually pass through your will. So we talked at the beginning about a little bit on how not everything passes through your estate when you die. Not everything passes through your will. So tax-free savings account, life insurance, RRSP, RIF, those are assets where you can directly designate a beneficiary with your financial institution, and those do not pass through your will or through your estate. Those pass directly to the person that you've named, or if you've named a charity, they can pass directly to the charity that you've named. And then gifts during your lifetime. And so under the testamentary, let's go back there for a sec. Gifts in a will, there's two types. There's cash bequests, which is a specific amount of money, or a residual gift, which is a percentage of the overall estate. So look at cash bequests first. So an example would be, I direct my trustee to pay $10,000. Oh, there should be an extra zero there. Sorry about that. Not $1,000, $10,000 to TB vets. Pretty straightforward. The important characteristics of these, they're easy for the executor and trustee to make. We know how much is happening, we know how much is being given, and we make it. These are paid first before any percentage beneficiaries or residual beneficiaries. So the order of operations would be your executor, trustee means the same thing. They pay your taxes, pay your funeral expenses, deal with any of your domestic contents around the house. They make the cash bequests, and then they pay what's ever remaining. That's why it's called the residue to your percentage beneficiaries. So cash bequests come out first. Another advantage or disadvantage, depending on your view, if you receive a cash bequest in a will, you do not have the right to a comprehensive report from the executor or the trustee, which is the same thing. But if you have a residual percentage left to you in a will, you actually have the right to receive, within a year of the person's death, a full spreadsheet from the executor showing what everything has been spent on, so where money went, what the taxes were, if the executor is being paid any fees. You have the right to see that and approve that. And in fact, as lawyers, we do not advise that the executor distribute the estate until they have the sign-off and consent of all of those percentage or residual beneficiaries who have the right to review those reports. Cash bequests do not have that right. So if you're someone who wants to contribute to a lot of different charities, it can be a good idea to give them cash bequests rather than residual percentages, because the work for the executor is going to be so much more in trying to get approval and review from all of those different charities when they're being left a percentage, rather than if it's a cash gift, they just say, great, 10,000 to TB Vets, 10,000 to BCSBAs, 10,000 to the Children's Hospital, a couple other thousand here and there, and they're done. They don't have to do anything else except for just give the money. These are often also very well suited for people who have a sense of stability about what their estate is going to be worth. So if you know that your estate's probably going to be $1 million, you can budget for these expenses. If you don't know, so if your estate is likely to go up or down significantly in value, these might not be the best because, as I say, they're paid out first. So let's say you thought your estate was going to be $1 million. You gave quite generously to charity in cash bequests, but you want everything to go to your niece and nephew in the end. And over time, you actually spent a lot of your estate, or your stock portfolio didn't do so well. So you don't have $1 million anymore. You only have $500,000. Well, your generous bequest to charity, those actually get paid out first, and your niece and nephew might end up with a lot less than you anticipated. So that's a caution or advice on that. It's not always suited if you don't know the value of the estate. But it can be really helpful to leave cash bequests when you know you have a general sense, a pretty good sense of a stable value of your estate. And if you've got a spouse and children, like a really good example would be, you know that your estate's going to be about $1 million. You don't expect it to change. You are a widow, you have 2 children, you want your children to inherit the majority of your estate, but you want to leave a couple $10,000 cash bequests to your favorite charities. That's totally doable, totally acceptable, and it works very well with a cash bequest. In that situation, I would actually recommend a cash bequest rather than a residual percentage, because you don't want to have to wait for those charities to consent in order to get the money to your kids. This is the other one. So the gift of a residue or percentage in the will. So an example would be, I direct my trustee to distribute 20% of the residue of my estate to TB Vets Charitable Foundation. So you're giving a percentage of your overall estate. Important characteristics. So in contrast to the ones I just mentioned, these folks have the right to receive the comprehensive reporting from the executor and trustee and to actually approve that accounting, that information. These are paid out after the cash bequest. So that's what I was talking about earlier, when if your estate has really declined in value, this amount might be smaller than you think. This option is often best suited for people who expect their estate to change a lot in value. So if you know that you want to benefit your 3 favorite charities, but you expect you're going to spend a lot of your money during your lifetime, this might make sense for you, because then you're not setting an exact amount. You just know that those 3 favorite charities are going to benefit from whatever you've got at the end of the day. It's also better suited to people who don't have a living spouse and don't have children, because you're not having a delay in waiting for these charities to approve the distribution before the funds go to your spouse and children, who would normally be your larger beneficiaries. Another way to give is giving through a tax-free savings account, RSP, or life insurance policy. So as we discussed before, these are actually not part of your estate proper. They don't flow through your will. They just pass automatically to whoever you've named. So this can be a really nice way to give to charity, where let's say you want your kids to inherit your estate, the majority of everything you've got, but you have a little tax-free savings account of about 25,000 in it. You want that to go to charity. It can be very easy just to name your favorite charity as the beneficiary to that tax-free savings account, and away it will go on your death automatically to them. These are also not subject to will's variation. So we're going to talk about this in a bit, but as you've probably gathered with me talking a lot about spouses and children, not only do you probably want to give to your spouses and children, if you don't, they can apply to vary your will and make everything very difficult for your other beneficiaries and for your estate. So even if you want to disinherit a particular person and leave most of your estate to charity, it's just often not a good idea. But leaving things through a tax-free savings account, RSP life insurance policy, that does not attract will's variation because it's not actually passing through your will, it's passing separately. And so that allows you to carve off some money for charity if that's something you want to do. You can also receive tax credits for life insurance premiums that you've paid during your lifetime. So if you do take out a life insurance policy naming a charity, you can claim a charitable tax credit for the premiums that you pay to maintain that policy while you're alive. Okay, the next and most obvious one is giving during your lifetime. And surprisingly, even though I'm talking to you all about estate planning, I think this is usually the best choice. The reason being you get to see your donation in action. There's better tax benefits for donating your publicly traded stock portfolio during your lifetime, if that's something you wanted to do. And we don't know how long the government will allow those nice rates, so possibly for a limited time only. The other reason is similar to the tax-free savings account or the RRSP, donations that you make in your lifetime while you're still alive can't be challenged by spouses or children later on. And so if you really, really want to give a significant portion of your wealth to your favorite charities, doing it during your lifetime is probably the surest way to make sure that that happens and ensure that you get tax benefits. I know it's not for everybody. A lot of us want to have money until the end of our lifetime to provide for ourselves, especially with people living longer and longer. But if you can donate during your lifetime, I think it can be really rewarding and securer than some of the other options. Okay, so important considerations. These are more for when you're donating in your will. But make sure you consider who are you giving to and be specific about it. We'll talk about special purposes gifts in a minute, but for those, my sort of takeaway is do some research first. And then remember that will's variation is out there, and we'll talk about that as we go. But these are some considerations to look at. Okay, so this lady here is like, huh, who are you giving to? You think this is easy, but sometimes it's not. So if you're giving to your favorite charity, are you wanting to give to the local branch or the national parent charity? Do you want it to go to a specific research charity like BC Cancer Research, or you want it to go to a general charity, just like the BC Cancer Foundation, different things? Make sure that you think about that and you get your lawyer to look up the full legal name and charitable registration number of that charity. So we want to know who are they, where are they, what is their charitable registration number. It's important because if you don't name the charity properly, there can actually be a dispute about who you meant. So I had one in my career where it just said BC Cancer. Okay, well, like which one? There's a variety of charities that have BC Cancer in their name. And for that reason, we had to serve notice on all of those charities and actually get a court application to determine which charity she meant. So it can be a challenge. Other point is the charity registered? So is it a registered charity with CRA, Canada Revenue Agency? And if it's not, does it change your mind? So there are some things that we think of as charities that actually are not registered charities for tax purposes. Things like more environmental organizations like Greenpeace is a good example. A lot of those organizations are not registered as charities because charities are not allowed to make political statements or to like politically campaign for any particular legislation. So there are some organizations that want to do that kind of advocacy work and therefore can't be registered as charities. If you want to donate to an organization that you think of as a charity but is not actually a registered charity with Canada Revenue Agency, you can still donate to them. You just won't get a tax receipt for that. You won't get those nice benefits. So does that change your mind? Next one is this a Canadian charity? So it is generally not great to donate to foreign charities in the will because the tax benefits aren't, well, one, the tax benefits aren't really there, or it can be harder to claim them. And it's harder for the executor to get the money to the charity, especially when you're talking about charities that expect it in a different currency. That can be quite challenging. So unless it's something where you have a really, really strong connection to that foreign charity, you especially want to donate to them, it's better to find the Canadian branch or the Canadian equivalent of that worldwide charity and donate to that instead. It's easier for claiming the taxes or tax benefits, and it's just much easier for your executor. All right, my lovely pony here to talk about a special purpose. So a special purpose is when you specify the use that you want the charity to put that gift to. So an example here would be, I give the residue of my estate to the British Columbia Society for the Prevention of Cruelty to Animals, so the SPCA, for the purpose of miniature horse rescue. Now, that's a nice gift, but it's very, very specific. How many miniature horses are in British Columbia? How many of them need to be rescued? How much are you giving to the SPCA for that they might be able to use for other purposes? So the trouble with these is charities actually take them very seriously. So charities want to do what you said with that money. And so if they don't think they can use the gift for that special purpose, they might not accept the gift, or they might have to reapply it, figure out what to do. Sometimes it results in a court application where the charity needs to get some clarity from the court that they are in fact allowed to accept the gift, but not use it for that specific purpose. So before you put a specific purpose in a will, you want to consider, does it fall in the charity's scope? So does it make sense to give this gift to that particular charity for this particular purpose? Also consider how large the charity is. The larger the charity, the more likely they'll be able to use it for the particular purpose that you want. Consider if another charity is better suited for that purpose. Sometimes it's helpful to check with the charity beforehand and see, like, can you actually fulfill this purpose? And then the other question is, can you make a wish instead? So you can absolutely say in your will, like for example, in the miniature horse example, we would just change the wording here. I give the residue of my estate to the British Columbia Society for the Prevention of Cruelty to Animals. It is my wish that they use this for the purpose of miniature horse rescue. The word wish in a will, we call it a precatory statement. It means that it's not legally binding. It's an expression of what you would ideally want to happen, but the SPCA in that example does not have to use it for miniature horse rescue. They will try, they can, but they do not have to. They're not legally bound by it. Last thing we're going to talk about for charitable giving is our sad old friend, Will's variation. So if you haven't been to my other presentations, I'll give you a little overview. Most people think that when you make a will, you can do whatever you want in the will. You can disinherit your children, you can give to your favorite cousin, you can do whatever you want. And while that's kind of true, like there's nothing stopping you from making your will however you want, there can be consequences after you die if you do not provide for your spouse, living spouse, and children, including your adult independent children. So this right comes into being under Section 60 of the Wills, Estates, and Succession Act in BC. And there's a presumption that your spouse or children are going to inherit all or the majority of your estate. And so if they are not provided for in that way, they have the right under Section 60 to say, this will is unfair. It does not adequately provide for us. We want the court to vary this will in our favor. So an example might be a very charitable couple, and they are going to leave their children $100,000 each, and then they want to leave the rest to charity. That is probably not going to work unless they've already spoken to their kids and made them totally aware of that, and the kids are on board and say, yes, we understand, we'll take our 100 grand and run. Unless that discussion happens, The children would likely seek a variation and say, this does not adequately provide for us, given that we're the only heirs, and they would likely win. It's not that they would get the entire estate. The charity is going to get something because the court will always balance your right to make your own decisions about what you do with your property and the right of your children to an adequate inheritance. So there will be a balancing there, but you're not likely to get what you wanted, which was 100 grand to each of your kids, the rest to charity. So if will's variation could be an issue here, how to deal with it? One way is to give a smaller amount to your favorite charities. It's sad, I know, but often that makes it easier for everyone. Another option is letting the family know what to expect. So I touched on just there. So let your kids know, okay, like we're going to give the most of our assets to charity. And if they're on board, it's not going to be an issue because this depends on your kids or your living spouse causing a fuss. If they get the will and it says 100 grand to each of my kids and everything else to charity, and they don't blink an eye and they say that's what mom and dad would have wanted, your wishes would be honored. It would go that way. It depends on your kids causing a fuss. Another way to avoid it, as I said earlier, is give during your lifetime. Give your stuff now, get to see how it does and get your tax benefits while you're alive. Your kids can't contest things that you've done before. Or give through the tax-free savings account, RSP, or life insurance, which as I discussed before, have that ability to give outside of your will. The only other thing I'll say about will's variation is be careful. This is more tends towards my blended family presentation, but I'll just give you the PSA. Be careful about who is a spouse. So you are technically spouses with another person for the purposes of inheritance if you've been living together in a marriage-like relationship for more than 2 years. So common law spouses can happen. They are actually fairly common amongst people on their second or subsequent marriage. And it might be that you don't realize that it's happened. So it can sneak up on you, and it's something to consider. So that's my public safety announcement on that one. So I went through that pretty good time. So we've got some time for questions. This is my contact information here if you want to see my details. And then otherwise, I think I'll probably check the chat to see if you got any questions in there, or I can take questions from the floor as well.
Yeah, there's a good question in the chat.
All right, I'll grab it. I'm going to stop sharing my screen here. Okay. Where do the executor expenses come out? What priority? So the executor expenses come out right after taxes. So taxes always have first priority. The government wants its cut. After that, your executor's fees. So some executors don't charge fees. So if you name a child, a relative, those people generally don't charge executor's fees because they're already inheriting from the estate or they love you, so they're not going to charge you. If your executor is charging fees, technically you have a right as the executor to charge somewhere between nothing and 5% of the estate. So some executors will charge and of course be reimbursed for their out-of-pocket expenses like getting rid of your junk, redirecting your mail, all that kind of stuff. Those get paid out right after taxes. So taxes, executor fees, and expenses. And then the other question was, what if the will doesn't name specific charities, but just has a cash provision to give to charities as per the executor's discretion? Do the various charities need to be given an accounting of the payout? So I assume a cash provision would mean like $100,000 to charities as my executor in discretion determines. If that's the case, no, because it's just set that it's $100,000. So your executor would not have to report to the charities about the rest of the estate. They would just say, okay, $100,000 has been set aside. I'm going to apportion it 50 to this one and 50 to the other one. And they would just write a letter saying basically, hello, I'm the executor. I have the right to appoint charities and I have appointed you. Thank you. Please accept $50,000. If it's a percentage, probably yes. So if it's a percentage, like you could say, I'm trying to explain here. You could say 100% of my estate, all of my estate, to charities as my executor in discretion may choose. Like you can do that. It's legal. It's weird, but you can. Um, in that case, your executor is probably going to make an accounting for those charities in like whatever percentages they decide. So in that case, I mean, to make it easier for themselves, they're probably only going to pick 2 or 3, but they would provide that accounting to, because they are residual beneficiaries, they're percentage beneficiaries, they would provide the accounting documentation saying, I spent this, I spent this, I spent this, I spent taxes, and now you get paid whatever's left over. Any other questions?
No other questions?
No other questions? That's okay.
Okay, if that's the case, I'm going to say thank you very much, Raya.
Yeah, thank you.
I was pronouncing it wrong.
That's
And
okay. A lot of people do. Yeah.
oh, do we
One
have
question. You referred to the 2 previous sessions. Are they recorded somewhere?
I'm not sure.
I can find out for you, and I believe they're on we post them on YouTube. I'm not sure how long they stay there because Rhea recorded them last year.
Yeah,
Yeah.
if you are interested, I can also, I think that TB vets should already have them, but if you want my presentation notes, like if they're not recorded, but you want the notes from the other presentations, we can do those. And I might, depending on the appetite for them, they could be redone as other sessions. I've only done each of them once, but I will tee up with the folks at TB Vets about that.
Great. Thank you.
Yeah, it would be great to have you present again,
Oh,
especially on blended families.
yeah.
It's common, and there's lots of technicalities or ins and outs with blended families. Yeah.
Someone asked, is there a way to get siblings to sign doc? I assume that you're talking about when you want your siblings to approve the accounting of the executor, or I'm not really sure what that means, but oh, they're too lazy to agree. Um, So, after 210 days from the issuance of the grant of probate, you have the right, if you're the executor or the trustee, to distribute without the consent of your siblings, of the other beneficiaries. You can say, that's it, I'm done with you. I am distributing from this estate. The risk with that is they could come back later and say, oh, I didn't know everything. I didn't know this and I didn't know that and I didn't agree. So if you're stressed about that, if that's something you don't want to have happen, you can do what's called a formal passing of accounts before the Supreme Court. It's a court application. It costs between $3,000 and $5,000 for a lawyer to do it. It's not fun. Those expenses are paid by the estate, so they're not paid by you personally. And basically, you just provide your report as the executor to the court, and the court says, yes, this is okay, and like kind of cleans you of that liability so that you can distribute without fear that your siblings are out there hanging out and coming after you. It doesn't happen very often. It's very, very rare to pass accounts. I've been practicing for 5 years and I've never actually done it. I've threatened to do it. So one of the things that we sometimes do for unresponsive or lazy beneficiaries is we say, if I'm the lawyer for the executor, you have until X date to consent or get your comments about this into me. And if you don't, we will pass accounts and that will be taken out of the estate. So if you want to get a significant enough, like, you know, it's about $1,000 per sibling, depending how many you are, be lazy. Otherwise, deal with it. Oh, someone put a link.
Yeah,
Is that, I don't know if that's my presentation or,
it is.
oh, it
Yeah.
is.
I
Okay.
haven't found the others. I haven't found the other one yet.
Okay. Yeah, that will be probably my first presentation on the fundamentals, and then there's a blended family one as well. What we could do, and we can discuss on TV Vets, but I would be willing to if people wanted, basically like a sort of a back-to-back situation where I could represent these three sort of in succession. So either on one day or on multiple days, so that if you wanted to attend all three, you could see them kind of as a group. Yeah.
Okay.
All right. Is that all the questions out there?
Now, your blended family ones here as well.
Mm.
Okay, great. Great. Okay, well, Raya, we can speak in the future to present those again because
So them again, or we can do another one depending on what people would find useful or helpful.
yeah, be great.
All right. Well,
Yeah.
if that is it,
Thank
I
you.
have released you 4 minutes early.
I wish everyone happy holidays and look forward to seeing everyone in the new year as well. And thank you again, Raya. Very
You're welcome.
interesting.
All right.
Yeah.
Bye, everyone. Have a happy holiday.
Yeah. Okay.
Thanks so much, Raya.